Hey there, you want to know what Melinda Gates' lawyer's unusual move was in their divorce filing? Stay tuned and I'm going to tell you. Hi, I'm Rebecca Zung, and I'm an attorney and I'm an author and I am a negotiation expert, and I specifically focus on teaching people in business and in their family law matters or other matters on how to negotiate with narcissists or high conflict personalities or difficult personalities. So if that's you and you want to be the most persuasive person in any room that you walk into, then make sure you hit that subscribe button and hit that notification bell. And that way you'll get notified when I upload new content. Okay, so let's talk about this Gates divorce. So I saw an article and it was talking about Bill and Melinda's divorce and this unusual thing that one of the lawyers put in to the petition, and it like sent off some red flags. And so I wanted to just break it down for you. I love to use these things that are in the news as, you know, they're interesting to talk about. And it also is like an opportunity to learn about what's going on in maybe in your life. So, and, you know, help you come up with ways that you can actually maybe think outside the box and start creating your strategy and your leverage and all that good stuff. All right. So let's talk about Bill and Melinda. So they have 3 children, and they have been pretty vocal, at least Bill has been pretty vocal about the fact that his children are not going to inherit billions of dollars. He has said that for a while now. They have 3 children who are, let's see, Jennifer, who's 25, Rory, who's 21, and Phoebe, who's 18. And apparently they're only going to be getting only 10 million each, only because it's really kind of like pocket lint. For anybody else, it's like finding change in their like sofa cushion, since, you know, they're reportedly worth way over 100 billion. I don't know exactly how much, but it's a lot. And so he proudly announced to the world that the kids are only going to get 10 million each and the rest is going to be left to charity. Apparently, he said in a 2016 interview on a British morning show that his children were not only okay with that, but they were proud of him for it. This is what he said. He said, "Our kids will receive a great education and some money so that they will never be poorly off, but they'll go out and have their own career." Then he went on to say, it's not a favor to kids to have them inherit huge sums of wealth. It distorts everything and anything they might do, and he wants them to create their own path. So, but the divorce might actually change that, because once Melinda gets her share of the piece of the pie, and I've heard rumors that there's no prenup. And, you know, by the way, I have another whole video breaking down on what will she get. You should definitely check that out as well. But anyway, the divorce might possibly change that, because Melinda, might have the opportunity, or she will have the opportunity, to create her own new estate plan. So here's the unusual thing that's in their petition. The petition, which is the document that is filed with the court that opens the divorce case and gets everything going, that's the document that you have to put like generalities in big, broad brush strokes of things that you want in there. So you don't specifically put, you know, I want this coffee cup, but you would say, Your Honor, or Judge, Court, divide the assets accordingly, you know, divide them according to equitable distribution or community property or whatever the laws are in your particular area. So you're just going to say divide them equitably, or whatever the language is. So you're not going to break down each particular thing, but you're going to address the fact that there are assets that need to be divided, and how do you want to divide them, you know. And so you wouldn't say, I want $5 a month for alimony. You would just specifically ask, you would just in general say, I want alimony. And if there's different types of alimony in your particular area, you might reference each one of those. So I'm telling you all of this because it is a document that you ask for things from the court. And in general, the judge or the court can't give you relief that you haven't specifically asked for in a pleading. So in general, you can't just go into court and start asking for alimony if you didn't ask for it in your pleadings, okay? Sometimes there's exceptions to these things, but I'm just giving you generalities here. And obviously you have to consult with an attorney in your particular state, country, or jurisdiction to get the laws that are specific to you and legal advice that's specific to you. But here's the crazy thing. So her divorce petition actually mentions America's top trust and estate attorneys. And they're actually named in the petition for dissolution of marriage, which is highly unusual. You don't normally name estate planning attorneys in a divorce petition like that. But there's a number of reasons that that could be happening. One is that it could be that there was an irrevocable trust. So it could be that maybe they put assets into an irrevocable trust. She now wants to break the trust and pull those assets back out so that she can get access to them. So I have had to engage an estate planning attorney myself in order to do that. And especially if like one person put the assets into an irrevocable trust without the other person's permission, then you even have more grounds to potentially break that trust. It's really hard to break an irrevocable trust though, by the way. So, but that's one reason. I mean, it could just be that she's thinking she wants to change her estate plan and she maybe wants to change it up so that she gets more of the assets, and she may end up down the road then being able to give the children more than what Bill had very proudly told everybody that he was giving. So the point that I want to make though for you guys is that, back to what I was saying before, is that I kind of call the petition sort of the kitchen sink, because you want to make sure you ask for everything that you might possibly want. You can go back and amend your petition later, but usually once the other person has answered your petition, then you have to ask the court for permission to amend your petition. And sometimes if you're too close to trial, or you're too close to the end of the case, or it's gone on too long or whatever, the judge will say, no, you're not allowed to add a claim. But sometimes you can. So, you know, if there's anything that you think that you might want, you generally put it in the petition just so you cover your bases. So, for example, if you don't want alimony, but you think maybe you might, or maybe it'll end up being good leverage, you want to make sure that you put that in there right from the get-go. Sometimes people put in tort claims, sometimes they put in claims to try to have the house sold, things like that. So you are putting everything in there that you might possibly want, because it just is a little bit harder to go back and ask for something down the road if you get too far down the road and you haven't asked for something that you end up deciding that you want. So it's a little bit unusual to have estate planning attorneys be referenced in a petition, but there are probably really good reasons for it. And if you are going to go for what you want, I want you to put in the comments, I'm going for it. And this is just like even for life. You know, it doesn't even have to be a petition. If you're going for it in your life, I want you to put, I'm going for it. And if you're getting ready to negotiate with anyone, make sure that you grab my free Crush My Negotiation Prep worksheet at winmynegotiation.com and join my free private Facebook group, Narcissist Negotiators with Rebecca Zung. And if you like this video, make sure you like it and you share it and drop me that comment and subscribe to my channel and hit that notification bell. I am Rebecca Zung. I am so glad that you stopped by today, and I will see you in the next video.